Today I'm going to be talking to you about states' rights, federalism, and criminal justice, and in particular about the conflict that is brewing over marijuana legalization. And sort of to take this to a more layperson's level, what I really want to talk about is the relationship between the state and federal criminal justice systems. We have these two parallel criminal justice systems in our country, and so I want to talk a little bit about what they each are, what they're empowered to do, and really what happens when they conflict with each other, because as we're going to see, they have a fair amount of overlap. They can sometimes criminalize the same things, and sometimes they will, when they're coming into conflict, they may actually decriminalize certain things, as we're going to see with marijuana. So at the most basic level, we have, as I said, these two parallel criminal justice systems, and I'm sure that's something that we're all familiar with. We know that there are federal agencies such as DEA, FBI, Border Patrol, TSA, and a number of these agencies that deal primarily with federal crimes and issues. They work with federal prosecutors, such as I was when I was working in New York, and they enforce federal crimes. We also, at the same time, have a parallel state system. And so that would be, for example, your local sheriff, state troopers, and they would tend to work, for example, here in New Hampshire with county attorneys' offices, and they would be enforcing state crimes. And now I know we all know about this at some basic level, but probably you all haven't devoted a lot of time to thinking, what's a federal crime, what's a state crime, and what is the constitutional basis for those two systems to interrelate. So that's what we're going to talk about today. At the most basic level, the difference between a federal crime and a state crime is which legislative body has enacted it. And that sort of begs the question, but it's important to realize that the U.S. Congress in Washington enacts criminal laws, and so does the State House here in Concord. They enact the New Hampshire state laws. To talk about how these two systems interact, we need to look to the Constitution. And so that's what I'm going to be talking about today. What does the Constitution have to say about what can be a federal crime versus a state crime, and which one is going to take priority when they come into conflict? And again, as I mentioned, this is generally a really interesting question, at least to me, but I think it's becoming really interesting to people because of this issue of marijuana legalization. So let me just talk about that for a minute. As you're probably aware, because it's been covered fairly extensively in the press, Colorado and Washington State voted to legalize personal use of marijuana. And I'm not talking about medical marijuana now, because a number of states, in fact 18 states and growing, had already had medical marijuana statutes. What's different about what happened on Election Day is that two states have now legalized marijuana for recreational use, and both of those statutes allow people to possess an ounce or less of marijuana just for recreational use. They do impose age limits. They do impose some limits on where you can smoke it. And in terms of cultivation and sales, they set up an entire bureaucracy for regulating and taxing the cultivation and sale of marijuana. So generally it's run sort of like alcohol sales, slightly more restrictive, but for example, in the Washington statute, the state liquor board is in charge of marijuana distribution just the same way that it's in charge of alcohol distribution and regulation. So these are fairly revolutionary statutes in that they're doing something that has never been done before, and something that is still illegal at the federal level. What does the Constitution have to tell us about that? When the federal government makes criminal law, it does not have broad power to do so. It can only do so in a fairly limited way because it must rely on its enumerated powers. And there is no broad police power granted to the federal government under the Constitution. That power is reserved to the states. So when the state of New Hampshire makes criminal laws, it does so acting under its police power that allows it pretty wide leeway to criminalize whatever conduct conduct it would see fit and to do whatever the legislature feels is right with regard to criminal laws. However, when Congress and the federal government acts to make criminal laws, they are acting under the commerce power. And why is that? It's because crime affects interstate commerce. And I think that's sort of an obvious common sense proposition, but we know that if you're trafficking marijuana across state lines, that's essentially an economic activity, just like selling any other product. Other types of crimes can also affect interstate commerce. And so just briefly reviewing the text of the Commerce Clause, it says, Congress has the power to regulate commerce among the several states. And that's what we're interested in here. So when we're sort of whacking up what's a federal crime and what's a state crime, we have to look at the Commerce Clause, and that's how we decide whether the federal government has power to criminalize something. Now, interestingly, these guys have already spoken on the issue of marijuana. And they had to look at a case in which two individuals in California had been growing marijuana for their own personal medical use in a way that complied with California's, I think it's called the Humanitarian Use Act or something to that effect, their medical marijuana statute. And those two individuals made a Commerce Clause argument. They argued that they were essentially growing marijuana in their own backyard. They were not selling it, and therefore, when the federal government came in to prosecute, that the federal government had no authority to do so because it was outside Commerce Clause jurisdiction. Well, the court disagreed with that. The court basically said anytime you're growing products that could be put in the marketplace, that is an act of commerce, essentially. And so the government is allowed, or the federal government is allowed to make a law that says marijuana shall be illegal, even if the individuals who are acting under the California statute are not actively selling the marijuana. They can still be subject to that federal law. So what happens to the individual in Colorado who decides that they want to sell marijuana under the new legalization statute in Colorado? What happens if the federal government decides to come in and say, too bad, you knew this was illegal at the federal level, we're sending you to federal prison? Well, the bottom line is that the Supremacy Clause says that the federal government is entitled to do that. The Supremacy Clause basically decides what happens when these two bodies of law come into direct conflict. And it says that this Constitution and the laws of the United States, which shall be made in pursuance thereof, meaning laws like the Federal Controlled Substances Act, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution and laws of any state to the contrary notwithstanding. So what does that mean? It means that if you're in Colorado and you decide to sell marijuana, and you see a state trooper, you don't need to be worried, but if you see a guy in a DEA jacket, you should watch out. So thank you.